Number 5, matter of State of New York versus Perb. Whenever you're ready, counsel.
Thank you. If I may reserve 4 minutes for rebuttal.
You have 4 minutes.
Thank you. If it may please the court, my name is Clay Lodevice. I am an attorney with the State of New York Office of Employee Relations. As set forth in our papers, the Office of Employee Relations is the agency entity responsible for acting as the governor's agent for collective bargaining for the State of New York as employer. To be clear, as I also set forth in our papers, we do not represent the Department of Civil Service in its role as the administrator of the merit and fitness system. This Department of Civil Service, through the President of the Civil Service Commission, is a distinct entity for that purpose. I also want to note one kind of reference as I'm walking through. Subsequent to the filing of the papers, the Office of Employee Relations returned to its statutory name, Office of Employee Relations, rather than the Governor's Office of Employee Relations. So I'll refer to OER rather than GOER throughout the statement. The first point...
Counsel, what would your definition be if we're looking at an issue? What's your definition of a term and condition of employment? How do we apply that term?
It is something that applies to the individual in their status as an employee of the public employer. It has to be tied to employment. It's my salary, it's my wages, it's my leave accruals, it's how much have I paid for overtime, under what circumstances do we schedule shifts.
Is it a fee for a promotional exam? Is that a term and condition?
No, I would say that it's not, and I would say that on several reasons. First of all, is that the statute is very clear that the fee is applied to applicants or candidates for prospective future employment, whether it be for an open competitive exam or a promotional exam. The statute makes no distinction between the status of the individual as opposed to as someone from the public or someone who is has a qualification for that future appointment for promotion has to be a public employee. So the statute in itself distinguishes it as applicant or candidate.
That's a fair characterization to someone looking in from the outside, but from the perspective of the employee, they're an employee looking for career advancement. They want to move up in their workplace. So the ability to do that without fees being attached to it could very well, from their perspective, be a term and condition of their employment.
Well, that is also true for the individual who is standing on the street who is not a public employee at that time, or not an employee.
Well, they're certainly not advancing in their career as a government employee if they're not employed by the government at the time.
Well, and I would also state, and I think 2 further points on this in terms of being a term and condition of employment. The other is I think that you should look in terms of the statutes of the cases that underline the question if this is a mandatory subject of bargaining. We'll refer to the 207C cases, the Board of Education case. In each and every one of the statutes that's presented to the court, the language used by the legislature refers to an employee. For the case of 207C and the derivative 207A, those cases refer to like a police officer, a deputy sheriff, an undersheriff, and speak to which the employer can handle. There's the Board of Education for the City of New York. The statute in that case spoke specifically of the city board, what it could do in terms of financial disclosure as it relates to an officer or employee of the city school system.
Is it possible to look at this as a bifurcated inquiry? First step being, is the fee is the exam, and a particular score on the exam, taking the exam, a term and condition of employment, and yet find that the fee, and setting the fee, paying the fee is not necessarily a term and condition of employment. Is it possible to look at it that way?
Yes, I think there's more layers to that. I think the first inquiry the court must make is to answer the question of whether the Department of Civil Service, through its authority under Civil Service Law Section 6, Section 7, and then through Section 50, is acting as an employer. We present that it is not. It is acting in its individual authority derivative of a responsibility under the United States, or the New York Constitution.
Let's suppose that's right for a second. Doesn't that just kind of push the bargaining question down to who is the employer, right?
Yes.
So essentially, instead of saying you can bargain for this to be waived, you can bargain for your employer to reimburse you for it.
So, yes, no, I think that, yes, the reimbursement, I think, is actually the correct answer in the long term for
Right,
this
is that
case.
the Civil Service Department can say it's a $100 fee, and that's what it is, and nobody can challenge that, but what you perhaps can do, or the question is it mandatory or permissive, so on, is with your particular bargaining unit, can you negotiate for a reimbursement of that?
Yes, and if we reach the point that it's an employer, it's a term and condition of employment, and then what's the question of whether the statute exempts it, and then we get down to that part. And this goes to the case that both CSEA and NYSCOBA talk about to establish the idea that this is an economic benefit. And one of the provisions they put out there is tuition reimbursement. And tuition is something that the state university system or other education system would set, and then there's a negotiated reimbursement for employees who choose to further education, whether to advance their job or for other reasons. And we have a negotiated reimbursement. But what is not negotiable is the ability of the State University of New York, who for this purpose would stand in the same status as the Department of Civil Service, of setting tuition, which will affect the public employees, whether they be SUNY employees or OER employees or Perb or, correction officers who choose to do that. But the negotiability is not tuition. SUNY is privileged to set the tuition, but once that is set and an employee is impacted by that, they can negotiate it. So here, what we believe, and I think our brief touch, is that the appropriate outcome is civil service can act in its status as the administrator of the merit and fitness system pursuant to the statute that is a very specific statutory directive of rights and obligations. And then once it's set, whether it be $15, $100, each of the respective public employee unions within the state of New York can approach OER and say, we would like to negotiate something to offset the impact of that. We want to create a pool of money so we can reimburse those employees. That's perfectly appropriate. That's what the tuition reimbursement is.
Is that permissive or mandatory, that bargaining?
I would proffer that that's a mandatory subject negotiation. I don't want to commit to what Mr. Fly would say, but I believe that that would be where the economic benefit is. Similar for the other public employers that are covered by the General Information Bulletin, the Thruway Authority, the Canal Corporation, the Bridge Authority, they can also approach their public employer and make the same demand, saying, Department of Civil Service, through its statutory authority, just increase the open competitive exam fee and the promotion exams, and we've been paying it, so we would like to negotiate a fund to offset the impact that on our employers. We believe that's perfectly appropriate, but that does not say or mean that the Department of Civil Service, when it's acting in its statutory role, derivative of the U.S. the New York Constitution, Article 5, Section 6, that to administer the merit and fitness system, that is negotiable, or that civil service is acting as employer, or that the fee is a term and condition of employment.
Isn't this the issue that Perb said that they weren't going to consider because it hadn't been made in front of the ALJ? Whether
Yes,
they were
in terms of the employer
The
part.
employer, yeah.
But they have considered whether it's a term and condition of employment, and they've said just because it's money, it's an economic benefit. And in that case, I would also proffer something more closer to the court. The Office of Court Administration, as we all know as attorneys, there's a biannual fee. That figure is set in statute, so I think even Perb would say is non-mandatory, the $375. But recently, the court system applied and passed through an administrative fee. I think it's to whatever the credit card cost is. There's like a 3% fee applied to the $375. Under Perb's view, that the attorneys within the Office of Court Administration, who are public employees and a representative, they have enjoyed for years not having to pay that fee. Now that has been set, it impacts them because it's money, they've had an economic benefit, so it makes any fee set by the employer paid by the public employee arguably an economic benefit that's a
So I'm
term
sorry,
and
is
condition
your
employment.
point that not every economic benefit is a term and condition of employment?
It has to be tied to the employment situation, and this is not. It's tied to a candidate for potential employment. And with this, I think it's important to highlight that I think it's somewhat of a shifting argument that we've moved through with Perb. The question of whether Perb is saying that
But you can't hold the job without having taken the exam and scoring wherever you need to score, isn't that correct?
that's true for the open competitive examinations also. And the reason I'm making that point is that Perb is asserting, I think, at least as I understand it, the only reason civil service's fee in this case is negotiable is because civil service is within the pyramid of the executive, one of the 60 or so appointing agencies that are under the state of New York. And because civil services is doing it as it relates to employees in that group, it's negotiable. But it necessarily means, if you take that argument to its logical conclusion, that it is not a term and condition employment as it relates to public employers other than the state of New York to which the Department of Civil Service is assessing the fee. So for the throughway authority, there can be no argument that civil service is acting as public employer vis-a-vis the throughway authority, the Canal Corporation, or other municipalities to which it may administer fees and, assess these fees. So Perb has made it so, like, we have a multi-lane highway to which Section 50 covers the administration of exams, open competitive exams, promotion exams, and Perb is effectively saying that civil service stands as the public employer only to a subset of promotional exams, which is a small group of that, and then there's this whole other lane that the statute covers for open competitive. And respectfully, we believe that when the court makes its de novo review, independently assessing the statutory balance that we have here, it must look at Civil Law 50 as a complete statute, not simply under the prism of the small subset, although maybe numerically large because the state's a large employer, the small subset of state employees.
How does our limited review affect this analysis, if at all? If at all?
I believe that you should weigh it's an independent de novo review. Perb has no deference in this case, and I think that they have no deference on several legal issues. First, whether Department of Civil Service, pursuant to the constitutional mandate, pursuant to the authority vested in the Civil Service Commission through Civil Service Law 6, Civil Service Law 7, and then 50, whether it's acting as employer. I think there's no deference to Perb. The second question is whether or not this is a term and condition of employment because it's a fee applied to applicants. There should be no deference to Perb. It is de novo review. And then the third statutory part, which I don't think we've touched upon, but is whether or not if the civil service is acting as an employer, whether this is a term and condition of employment, whether it is exempt from bargaining pursuant to the plain and clear language of Section 50.
So there's a little nuance I want to make sure I've got right, which is that you're saying it's not a term and condition of employment if you're thinking about the fee that is set by the Department of Civil Service, but it is a term and condition of employment if you're thinking about bargaining within your unit to get a reimbursement.
To get a reimbursement. And we wouldn't dispute the reimbursement.
Right, it could be the exact same money, right?
Could be but
And it goes to the exact same purpose, paying for the promotional exam, but it has a different legal structure.
the difference is, and it may be like the cart and the horse issue, the difference is civil service can set the fee because the statute says they can set the
You're
fee.
saying that's not bargainable? the fee
That
set
is
by
not
civil- but
bargainable, but
The reimbursement
once-
of that fee, even if it's a complete reimbursement, is mandatorily bargainable.
Which is, and goes back to the example of tuition reimbursement, or
All right,
going
let me-
back.
I now am confused. Does that mean that they could negotiate not to pay the fee? And no one ever pays the fee?
No.
I didn't think so.
No,
Okay.
because civil service still has the right to, well, they have the right to do three things. They can abolish the
Yes.
fee, they can waive the fee, or they can set a uniform fee and then set forth the class of the candidates, the types of exams. So civil service can do that. But once they do that, it is okay and for the CSEA, NYSCOBA, to approach the state of New York
Yes.
to say, our members now have to pay $15 every time they apply for an exam. We would like to have a fund of money that we administer that pays, or that we.
Where's the money coming from?
It comes out of labor management funding. We have lots of, it could come out of the tuition reimbursement funding, but that's something that would be negotiated. Similar for the groups of employees that we have in this group, the Teamster union that's in the Thruway Authority could go to the Thruway Authority and say, civil service just assessed this against our folks. We would like to create a fund for this.
Suppose we found that the fees were a permissive subject of bargaining. Does that make the terms and condition argument academic?
Well, I think that you still need to determine that the civil service is acting as employer. The application fee is a term and condition of employment. And then the third layer is whether or not it's exempt under the watered-down test and things that. And I see the white line, I just want
Can
to
you
make.
just quickly explain why it is you think it would be exempt? Because this statute looks very permissive to me.
I would disagree that it's permissive, and I think that going back to your decisions in the city of Long Beach and then a little further back to the city of Schenectady case, you talk about when there's a specific statutory directive that evidences the legislative intent
The
to.
directive is you can abolish, you can waive, you can do a lot of things. You have a lot of options available to you.
I think that you have to look and search. First, Civil Service Law 6 and 7 both provide that the commission, Civil Service Commission and the President of the Commission can prescribe rules for the administration of exams. Then there's Section 50, and it's very clear, and this is where I think it's the specific statutory directive. First, and this is only assuming civil service is the employer for this, that the legislature was very specific on who makes the decision as it relates to the fee. It's civil service with approval of DOB. And our record shows that there was a period of time, annual review for both civil service and the Department of Budget, applied objective and reasonable criteria to make that determination consistent with the statutory mandate. The second specific statutory directive this is that the legislature limited what civil service is permitted to do. First, it can waive the fee, it can abolish the fee, and then it can establish a uniform schedule of fees. And that schedule of fees, the legislature tells civil service that they must specify in their notice what is the class of positions for that uniform fee, what is the type of examinations for the fee, and what is the type of candidates. And there's only one exception to that specific directive granted to civil service approving is for employees that are, or individuals that are unemployed and the head of household. So there's even a built-in exception of what they can do. So the statute's very clear in what civil service is allowed to do in the context of the fee. And this is all within the statute that directs civil service how to conduct competitive examinations, which is both open competitive and promotional. And finally, OER is excluded. And this is unlike other provisions of the civil service law where, like Civil Service 75, 76, direct that negotiation applies to these things that in the employment context. And there's other statutes within the civil service law, I think it's 159A, 159, 161, talk about civil service, division of budget, and the directive of OER working together. So the legislature knows how to include OER in the context of discussions with civil service and division of budget, and they excluded OER. So if we're talking about civil service as employer within the state of New York as the public employer, the legislature has been very specific that OER, as the agent of the governor in collective bargaining, is excluded.
Thank you, counsel. We can get the rest of this on rebuttal.
Thank you.
Thank you, Your Honor. Michael Foyce for the New York State Public Employment Relations Board. Everything you heard from OA today turns upon this distinction they believe is relevant employer, not employer, who is this, who is that. Interesting arguments they did not bother to raise before Perb. The reimbursement argument not raised before Perb. Most of the subways he rephrased the same argument, not raised before Perb.
I think they were questioned, so are you convinced now that they've been raised before you?
Well, yeah, but I do think the general procedure where a court in review of administrative determination does not reach beyond the material presented to the administrative law judge, who is then reviewed by the board.
But I think they were examples of why this is not, right? That's what the questioning, I think, was getting out, not these were specific legal arguments that needed to be raised so that you can consider them. I think they were examples of what would be a term and condition, what wouldn't, what could be bargained in comparison to what this would or would not be. So what would your definition of term and condition be?
Term and condition of employment is something, and there's many different areas in which they arise. They arise directly from contract. In this context, we are looking at a term and condition of employment that arose to a past practice. A term and condition of employment is as self-explanatory in the sense that it impacts the employee's employment, and it's something has a reason to expect will continue.
Where have we held that a past practice of something that's not a term and condition of employment morphs into a term and condition of employment, as opposed to a past practice regarding something that is a term and condition of employment?
Okay,
What case can you, I may have missed it. What case?
Let me see if I understand where Your Honor is coming from. I'm not aware of a court case that says that something that was not otherwise, could not otherwise qualify as a term and condition of employment becomes one because of a past practice. I understood Your Honor's question as saying is starting at 8 p.m. a term and condition of practice, is driving a car a term and condition of employment. Anything, almost anything, unless it's violative of another statute, can become a term and condition of employment.
Let's assume, but take Judge Rivera's question as I understand it. We all agree it isn't a term and condition of employment, but they've been doing it. Does that make it then a benefit that they have to bargain over?
No, no. And the reason why this is a term and condition of employment is based on a significant amount of not just Perb precedent, but this court's precedent, that where the employer operates in a manner to create an economic benefit, that economic benefit is a term and condition of employment.
So because this was an item of financial relief or financial benefit to these employees, it therefore translates to a term and condition?
Exactly. There are term and conditions which are not directly related to money.
What about the fact that there are a lot of other people out there in the broadest view of this scheme that for whom there is no waiver of the fee, so it's not an economic benefit of any kind?
Then it's not an economic benefit for them.
So every economic benefit is a term and condition of employment.
It may be a term and condition of employment. If the economic benefit stems in the first instance from a contract, it is a term and condition of employment from the moment the contract is signed. If there is a practice or by an employer which says you can have a car, it's not in your contract. When you were hired, you didn't have a car, but now I'm giving you a company car. And for 10 years, I let you drive that car. And at no point do I tell you I'm thinking of taking back the car. Or at no point I say you can only keep the car if you will use it for this or that. Then there's a question of whether, because of that past practice, the economic benefit of having the car is a term and condition of employment.
But who made the decision to give you a car in your hypothetical? Who made that decision?
The employer.
Who was the employer in your hypothetical?
I didn't specify, but I think the question I'm sure Your Honor is getting at is, in a multi-leveled scenario, where
Right.
you have Department X, Department Y, what have you, who is the employer? They all
person you have
could
a contract
create,
with?
anyone in the chain of command, if you will, the pyramid structure of your employment hierarchy, can create a term and condition of employment by giving you an economic benefit. If the governor says for all state employees, you now get free lunch. And for 10 years, governor after governor gives you a free lunch. I don't know what the answer is going to be before Perb, but it's a legitimate question to be phrased to Perb.
So then, let's go with what you've said there. If we were to agree with that, does that mean that if an employer then changes their mind, or has tried to change their mind and was unsuccessful, I think that's part of the argument,
Yeah.
that somehow on the record they had tried to get DOB's permission for the fees, couldn't get it, finally did, et cetera, et cetera. Anyway, does that mean that the employer now forever moving forward must negotiate? Or only for those who are currently employed?
Well, first, it would definitely be limited to those who are currently employed. However, I can't answer past that because you need far more information. The question, if it's not in a contract, is would a reasonable employee believe it would continue? In one case, brief before you, was the Spence case. It involved cause. In that case, the employees testified that they were aware that every year the employee decided whether or not you can have a car. So it was found not to be a term and condition of employment. In town of Islip, it was the reverse.
Yeah, but in town of Islip, unless I've misunderstood that case, and you can correct me, the court started out by saying Perb has always considered it a term of and condition of employment, and the court didn't do a separate analysis to figure out if it was a term and condition of employment. This strikes me as different. This is actually on the table. Is this a term and condition of employment? And it, as I understand this argument, is for the court to decide in the first
I
instance.
think if you go through the Genesis, go through the case law,
Okay.
yes, it was obviously Perb that first said it was a term and condition of employment.
Yes.
But I am reasonably certain that it was argued, at least at the lower levels, that Perb got it wrong. In other words, there were multiple arguments in town of Islip. One was that Perb was wrong, and two, that the remedy was too extreme based on the costs involved. They lost on one, they won on the other. And so I don't think you get the Court of Appeals opinion in town of Islip as structured, if not debated through, and I believe it was addressed by the appellate division, but I'm honestly, you caught me by surprise. I didn't.
Do we have to defer to your determination that it's a
On term and condition of employment?
Right, his argument is all of this is de novo.
No. As far as deference on the questions that arise underneath the Taylor law, mandatory bargainable, term and condition of employment, past practice, deference. Question of statutory interpretation, whether or not either explicitly or by clear and plain language, inescapably, implicitly, the statute forecloses. Normally, this court does de novo. However, there have been times the court has granted Perb some deference on that question based on Perb's expertise.
Well,
And since
Can we talk about that for a second?
Yeah.
55, is that exempt? Because we were hearing about how it is exempt from
what exempt? I missed the first part of your question.
50 sub 5.
50.
Whether that creates an obligation that's exempt from bargaining. Can we address that question?
Okay, yes, I do not believe it does. I do not believe it does, and I believe Perb is correct. I believe that it's up, as far as the standard review on that question, that's the Court of Appeals' choice. You could go de novo on that. I'd rather you grant deference, but I can't insist upon it. But no, it's not exempt.
Why is that?
Because the language of the statute itself on its face makes it clear that the legislature set up a wide range of things DSC could do, none of which it can do explicitly by itself. It then needs to go to DOB, and specific things that it can't do, such as charging fees to veterans, unemployed people on public assistance. You compare that to what you had in Long Beach, where it was explicit an employer can terminate you after 1 year, and yet things related to that explicit grant of authority were found to still be bargainable. In this case, there is no requirement by the legislature for a uniform system. In fact, the statute mandates that there will never be a uniform system because certain people will always be exempt.
Yeah, but otherwise, they are asking for uniformity.
Oh, yeah, no, there's no doubt the legislature has indicated to the Department of Civil Service that when we have you to operate, there are certain ways we want you to consider to choose between.
So
No-
what would the practical effects be if we affirmed? What would that look like? It would be fees of varying, they could vary by hundreds of dollars, and there could be thousands of different
No,
applications? What does it
Perb's
look like
deci-
practically?
Perb's decision does not go past bargaining units representing by 3 unions of current state employees. That's it. It
That's
doesn't.
it for now, but as soon as a decision comes, that will be expanded, or could potentially be, to other units.
Well, only if some other group of employees said that they had a reasonable expectation. PEF, another union, tried to get in on this. They were too late. And they're not. And if you rule in our favor, PEF cannot say, well, now I can go for it.
So it's
No.
only this group of...
Only this group. It has no other legs to it.
And again, I'm sorry, it is repetitive of me, so bear with me. It only applies to those who are current
Absolutely.
employees?
This is what was, the decision is limited to the IP that was filed before Perb. Not only that,
Maybe decades before
Yeah,
they're
yeah.
gone, but nevertheless,
Yeah.
it won't go beyond this group.
it isn't, because this case is based on the concept of past practice. And non-employees do not have an expectation that can raise to a past practice. A past practice analysis to find a term and condition exists only regarding current employees. There's no way to, so not only doesn't this decision speak to it, the analysis of this decision would not apply. And in fact, Perb has faced this question before, and regarding non-current employees, open competitive exam said, there's nothing for under the Taylor law prohibiting the fees. So that question was raised before this one. But this one is very narrow.
Why
It-
is any right that what is negotiable is simply the reimbursement?
Well, first off, they're not mutually exclusive concepts. The fact that a reimbursement could be a term and condition of, could be negotiable. It could be a term and condition of employment if it's been done in the past. It could be something that the parties can put in contract negotiation to seek in the future. That does not impact at all whether for undisputed for 10 years, and to be clear, they omitted, we stipulated the 10 years. In this record, no one was ever charged this fee. So since 1958, employees have come in, worked for the state of New York, and if they were a current employee looking for a promotion, they didn't pay a fee. That is a key factor.
Can I just clarify something in the record? How often were they trying, let's stay with the 10 years, were they trying, requesting from DOB to be able to?
There is
How
testimony.
long was that?
There's testimony, not including the one that led to the IP,
Yes, yes.
of 4 instances. That's what they put in the record, from 1958 to the present. Now, in defense of them, they were focusing on 1999 and onwards. So they might have been able to find some before 1999. On 2 occasions, there was DSC decided we would like to do it, talked to Department of Budget said no. On the other occasion, internally, there was some discussion in front of DCS about doing it, and they decided not even to ask Department of Budget. What's important, however, is these were non-public. No employee's reasonable expectation could have been impacted by these considerations, unlike in the other cases, such as Spence, where the employees were aware that the employer was considering changing the practice, trying to preserve its discretion or what have you. Internal operations of the state, I'm not saying they were improper, All I'm saying is that they don't impact the reasonable expectation of an employee if the employee has no way to know about
So
it.
you're saying if they had somehow externalized this dialogue about whether or not to start charging the fee, that would have defeated the argument that was made previously about the expectation of this financial
It would have been a
benefit?
very serious factor Perb had to consider. We would have to look at the entire record, how well-known it was, and what have you, but absolutely, we would have had to consider whether employees were aware or made aware that a benefit they had might be changing. We would have had to take that into consideration. That was not in the record before Perb. In the record before Perb, what they argued is, internally, we always thought we could change this. Look, in the last decade, on 3 occasions we tried before we succeeded. That's what they put before Perb. They never even claimed before Perb that anyone outside of the conference room at DCS or DOB was aware of this.
Thank you,
And-
Counsel.
okay. Thank you very much.
Good afternoon. Kevin Hickey on behalf of NYSCOBA. There's a lot of moving parts here, and so I'm coming in relief on a few of these topics. I want to first touch on the issue of, I think the state said that a term and condition of employment, by their definition, is one that is based on their status as an employee. I think that's quite telling here in the sense that you take a promotional exam when you are an employee. So I think we check that box of the definition. And the second box of the definition was whether or not it's based on something akin to an economic benefit, a salary, wage, leave, overtime. What happened here is the reason why we're all here is for years, they waived this fee for employees. No employee had to be charged a fee.
It's promotional and transfer, right?
True, but I think when you're talking about...
So the transfer could be to an open competitive position.
That's true.
So does that affect what you said just previously?
Well, a transfer would be a current employee as well.
Yeah, but the person, somebody, I could apply for the job, well, I am an employee, sorry. Somebody, one of my daughters could apply.
Well, yeah, I think it does, but I think for purposes of what the decision was here is the lion's share of the people were people that were taking a promotional examination and the people that are involved in here as well. And the litigants in this case, what they were employees. So I
I'm sorry,
think,
counsel, just to be clear, and I just don't know the answer to
Sure.
this. A promotional exam is only open internally?
I-
So I want this level of supervisor, you can only apply within that unit, or can you also have outside candidates, let's say from other state agencies who may be within different bargaining units?
I'm not as well versed, and maybe one of my colleagues here can explain as to whether or not people could go from outside. My understanding is they might be able to, but I do not know the answer to that. Mr. Klein, when he gets up, you can maybe pick that question up.
Would that affect your analysis if you can have outside candidates come in and apply for what's also a promotional exam from within position?
When you say outside candidates, you mean people that are not
Different
state
agencies,
employees?
not within the bargaining unit.
Other state agencies? My position here is that the state of New York is the employer. And so employees that had not prior had to pay a fee for years for promotional examinations, those employees would not have to pay.
Perb, I think lawyer just told us that that's only applies to these specific units who are present in this kind of
Yeah, the
action.
decision in this case is limited to these employees. And so for this case, our employees, the security unit, and CSEA's employees would be the only ones that benefit from this ruling. I see they have a minute left, and then there's other topics. We have not even touched on the question of the broad and sweeping rights that the Taylor Law has given. And I would argue that the Taylor Law, when it came about, because it came less than 10 years after this civil service law, it made a considerable change to the Taylor Law. The change is such, the word broad and, or strong and sweeping is what the standard has been applied by this court over and over again. Strong meaning it's a powerful public policy, sweeping meaning it dips into areas that it probably didn't prior. And this section, Section 50, is contained in the same civil service law as the Taylor Law. The Taylor Law now brings into Section 50, for this limited area, where it's talking about what happens to terms and conditions of employees, I would argue that the Taylor law has now made it a mandatory subject to
The
bargaining.
waiver follow your employees to other jobs outside of this where you are now? So if you're doing a transfer, would then you be entitled to the waiver even though if it's a different bargaining unit that has the position open?
I would argue that, yes, if they're, as their status as an employee, if they continue to be an employee of the state of New York, then yes.
To get back to the statement you made before that question, why is it a mandatory subject to bargaining? Why could it not be a permissive subject to bargaining, given the amount of discretion that seems to me to be contained in the statute?
Well, I would argue that the way the case law that's followed is that the only time it becomes a permissive area of bargaining is when the legislature has committed the entire topic. And I would argue here that the entire topic is, at first is they charge a fee to open competitive, then they can waive that fee or abolish it or find some other way of going. That area right there then is where it becomes mandatory. In that small area is now, it's not permissive because permissive would
What's
say
the small area you're talking about?
Let me retry. Rewind and retry. So what I mean is that on that limited area of whether or not to waive, abolish, et cetera.
Yeah.
The way the case law has always been is that it's permissive if you can commit the entire process. There is no process here. It's very open-ended, it's very discretionary. And so in that area is the room to bargain. And there's a lot of case law that's out there that says if there's room to bargain can be read into the statute, then it should be read into the statute because it's a broad and sweeping policy or strong and sweeping policy of the state of New York. So I would argue that in that narrow area, when the state of New York chooses...
If I'm getting you right, because the statute allows them not to impose a fee, that's why you can bargain it.
Yes, because it gives them the...
To persuade them not to or to get something else.
Persuade them not, because that area is wishy-washy. It says you may choose to not charge a fee. Well, what better way to find out whether or not you should charge a fee is to negotiate with your employees to determine whether or not we should charge a fee. So that's where I think the room to negotiate should be read into it from this long
Do
precedent.
you agree what's not negotiable is that an exam would be a requirement for a job position?
An exam is not negotiable.
That
That's
part is
part of
not
the merit and fitness system. I would argue a
It's
fee,
whether to impose a fee and the amount is the negotiable part.
correct.
Why isn't he correct that it's the reimbursement that's negotiable, not the setting of the fee?
Because then I think that gets back to Your Honor's good question with regard to the permissive aspect. I think the only time where the court has found that it's permissive is when they commit the entire process to a government official. I would argue that this entire process has not been, it's just very generic. It's open to waiver, it's open to abolishing, it's open to 50 years, as this record has shown, of not charging a fee to certain classes of people and certain types. And then frankly, there's even parts in there that talk about refunding fees in section 50A. So 55A, I missed a 5 in there. So,
All right, thank you, counsel.
thank you.
Good afternoon. May it please the court, Steve Klein for CSCA. I think we got to get our terms straight here and figure out what we're talking about with employees. Promotional exams are internal only. They don't apply to non-employees. If I'm not a state employee in one of the CSCA units, I can't take a promotional exam for that position going up. So that's got to be made clear. This is a term and condition of employment because it only applies to current employees.
So a transfer position is different?
There's no such thing as a transfer exam. It's transitional. That's the phrase in the statute, and a transitional exam fee is very similar to a promotional exam, still limited to only current employees. It's just another type of exam.
But it's the same pool that can apply
It's the same pool of current employees who can apply.
within the unit?
Yes. So now you asked a question about whether this right...
Well, let's just clarify that. So let's say I work for a particular agency, and so there is no way that I can apply for a promotion because, to another agency, because I'm working in this agency. Is that,
You can apply.
Am I getting that right?
The place you're going to through the promotion is set by the exam itself.
I see.
And what civil service has decided unilaterally, which it can do under the merit and fitness provision of the Constitution, what civil service has decided the exam promotes you to and where those positions are. We're not challenging any of that. None of that is at issue in this case. All that is at issue is whether current employees get to take those exams for free to go to other positions within the same employer, the state, not the agency.
Regardless of the agency?
Correct.
Right.
So I can promote from corrections to OASAS. I can promote from OMH to OPWDD. That's not the
You're
issue.
saying promote, but you are including in that a lateral move to a different agency.
Well, it wouldn't be lateral. It would be a promotion.
Well, why
But
not?
for
I mean, if I-
example,
if I work-
well, let me give you an example.
Sure.
I'm an LPN, licensed practical
Mm-hmm.
nurse. I'm represented if I work for the state in almost all positions by CSCA.
Mm-hmm.
I want to take a promotional exam to an RN position.
No,
in
I'm
a-
asking you something different, so your example isn't
Okay,
helping me.
I'm sorry.
Let's say I'm an LPN for a particular division, and I want to move to a completely different division of the state in the same position as an LPN.
That's not a promotion. That's
Right.
called a
Is that what
transfer
you're calling
under
it?
the civil
Right.
service law.
And the
Entirely
fee-
different provision
and
of
the
civil
fee for
service
that
law.
is waived. The fee for
There's
that
no
is
fee.
waived.
It's a
There's no
transfer.
exam.
There's no test.
There's no exam,
There's
is
no
there?
exam.
It's no exam. All you're doing is transferring from one appointing authority to another under Section 70. That's not a promotion.
It's promotion and transitional, not promotion and transfer.
Correct.
So your position is essentially the fee follows the employee here. So whatever promotional exam you're going for, it's waived, even if it's in a different agency, in a different bargaining unit.
The waiver of the fee applies to employees within the units that challenged the taking away of the benefit.
Right,
So
but
right away, we're
that in-
limited just to
Yes, I understand
CSCA,
that.
NYSCOBA,
I
and
understand
DC
that. But
37.
let's say you apply to a different agency covered by a different bargaining unit for a promotional exam, which I think, as I understand it, you can do. The fee is waived.
Let me go back to my example. I'm an LPN represented by CSCA. I want to promote to an RN title, registered nurse title, represented by PEF. I can do, that fee should be waived and has been waived for
No
10
matter what
years.
agency is
Right.
going to employ.
Once I'm now an RN and I want to take a promotional exam to a nurse administrator position, those are both PS&T positions. PEF's not in this case. Those people have to pay they have to pay the application fee. That's different. So it doesn't follow the employee once they're out of our unit. It only applies to employees represented by the unions that timely challenged
So
the
in your
change.
example, if I'm getting this right, the LPN in the PEF who wants
The
to take...
LPN is CSCA.
No, but let's say, yes, I got that example. Now, let's say it's an LPN, or maybe this is not possible. In the PEF, who takes the exam has to pay?
PEF doesn't represent LPNs.
Oh, so what?
So you
LPN
have a
is going to an
you have a
RN?
CSCA,
I see.
you have a CSCA represented LPN who wants to promote to a registered nurse title. That title is represented by PEF, totally different state bargaining
Because
unit.
PEF doesn't have an LPN, they start out with the RN?
Correct.
Okay.
I'm sorry, Counselor, you're out of time, but thank you.
Thank you.
Thank you. Just one real quick point before I go into rebuttal. The Perb raised the issue of whether they should be subject to arbitrary and capricious or substantial evidence for a hearing when it goes to the Supreme Court. Ultimately, we don't think that was appropriately raised. We think Perb waived that by agreeing to the stipulation of transfer in this case. But to the extent that the court does touch on this, we want to refer you to Civil Service Law, Section 213, subsection 3. That is the statute of judicial review and enforcement for Perb's case as part of their enabling statute. That statute specifically provides for transfer to the appellate division for questions raised under 7803 subsection 4, which is substantial evidence. So its own statute provides for a substantial evidence transfer to the appellate division, so we believe that's already covered by statute. The most important thing, I think, for rebuttal is Perb makes the, and I don't know what other word to use other than nonsensical claim that the decision in this case will only have an impact on the three bargaining units here and their respective units. We would agree that this case applies specifically to them as it relates to the 2009 setting of the promotional fee by the Department of Civil Service. It's retroactive. At this point, if we lose, when we walk out of this room, the fee for those three unions and their units is zero, and it's whatever the General Information Bulletin says for the other units. So there's no longer a uniform fee. But going forward, as we walk out this door, if civil service exercising its authority, seeks to waive, abolish, or otherwise set a uniform schedule of fees, or if a municipal civil service commission does this pursuant to Section 50, this case will now mean that all of those entities, whether it's civil service or the commission, has to meet with their public employer, request their public employer, negotiate this, and get approval from the unions going forward. So this case has a global impact on all
Only for those who are currently employees?
Well,
That was my question about the
only
reasonable
be-
expectation.
It's current
of the
employees
practice
just
and so forth.
because Perb is narrowly defining, saying that we only mean this for the state of New York employees, for the small set of state employees who are taking promotional exams. But the promotional exam
Who
structure.
had reasonable expectations based on the
Yes.
prior practice. That's
So-
what I understood their
Yes.
position was.
Yes.
So anyone new, right?
But the next time they set the test, so in 2023, civil service wants to modify the fee, the promotional exam will apply to the employees that are current. Similarly, it'll potentially apply to public employees who choose an open competitive exam for that. So it applies in, the one point that Mr. Klein pointed out is CSEA represents, and I hope I get this right, the LPNs, and PEF represents the RNs. So here the question is, when the RN test, the fee is for the position as an RN. Does civil service have to negotiate with PEF, who is the eventual position, or do they have to negotiate with the CSEA or PEF or NYSCOBA for the people that want to apply for that exam? So there's a question of how many unions do you have to negotiate for each class of positions, each promotional line? Because as Mr. Klein pointed out, the promotional lines sometimes start in one unit and end in another. And it could start in 2 units and end in another. So
But I thought his point was it's the person, because they're the
Well-
one with the reasonable expectation.
Our position is why this is not a term and condition of employment, because the fee applies to the exam for the promotional employment. The fact that some individual chooses to apply for that promotional position doesn't mean that the fee resides in the employee, it
Counsel,
resides
under-
in the test.
If we adopt that rule, if we affirm, you charge the fee for others as $100 an exam or whatever, let's hypothetically, and now you want to raise it to 110, would that be bargainable now in the future?
If we lose this case, yes. And I also want to point out, it would be bargainable if we try to go take PEF from 15 down to 0. We can't, negotiation is, if it's, Perb is saying, well, the economic benefit was 0 and now it's 15, so it's negotiable. If it was 15 and we moved it to 10, moved it to 20, either situation would be negotiable. And part of that's like a labor concept, fist in the velvet glove. We can't raise or lower things at a whim because it undermines the bargaining obligation. So the fact that it went from 0 to 15 or 15 to 0, that doesn't go to the question of bargainability. It just questions of what's the outcome of bargainability. Just like we can't raise or lower wages, for that. And the last point I would just say is that in terms of, and I read is the idea of the Department of Transportation vehicle cases. It did not rise and fall if we reach the past practice case. Those cases did not rise and fall on whether or not that there was notice to employees because of an annual review. In each of those cases, Perb held that because there was a published internal policy that put employees on notice that the employer retained discretion, acting on that discretion cannot create a past practice, so therefore the employer can act. The only difference in this case, as opposed to the Department of Transportation vehicle case for the PEF, the Spencer State, or the Picnic case, the DOH cases, in those cases, it was internal agency policies that accrued only because the unions in their initial instance did not object to them, so they accrued to a retained discretion. Here, we have a statutory declaration in response to the public policy established by the Constitution to administer examination fees that retain discretion. Here, Perb is saying that in an internal administrative policy that accrued over time stands at a greater level than a legislative declaration to implement this strong public policy derivative of the New York State
I know your
Constitution.
red light is there, but just very quickly, do you agree with this point that the counsel from Perb made, that those efforts to impose the fee that DOB did not authorize, or unsuccessful efforts, were all internal, no employee would know about it? Is that correct? I just want to make sure that's
That
correct.
is correct, but I don't think that that's the correct analysis based on the DOT vehicle case or the picnic case. In both of those cases, they talked about an announced, like for DOT, it was very specific. I litigated that case, so I know the reason that the state won is because the DOT internal policy said that we can give or take cars at the discretion of the state. So the Perb board held and argued successfully at the appellate division that because the internal policy retained discretion, there cannot be a reasonable expectation of any employee under that policy that they keep a car for telecommuting purposes. So it was the internal agency policy that made a statement of retained discretion that Perb held to vitiate any reasonable expectation. So therefore, the employer was privileged to act to give or take cars based on that policy. Here, we have a statutory declaration that civil service, only subject to the approval of DOB, can modify the fee under those specific restrictions we talked about before. So if you apply the vehicle case under DOT and the picnic case for DOH was years before, but most recently that DOT case where I'm relying on what Perb argued in the appellate division. Because there's a pronouncement to the employee is on notice, the union is on notice that this benefit can change at the discretion of civil service. That employee cannot have a reasonable expectation it will not change.
Notice here is the statute.
This is the statute. It's clear that civil service can change it under the statute. The fact that the internal deliberation, which we established, was objective and reasonable, and they complied with the statutory provisions, both civil service and DOB, was internal because it's really a budgeting process of why they did this, is no consequence for the Perb analysis under the DOT case, because it's the statement of policy that drove the decision for Perb.
But I may have misunderstood him, but I thought the point was the fact that you have that discretion, DCS has that discretion to seek out the approval of DOB and to be able to modify the fees is what then makes it a subject of negotiation. It is that fact.
Well, we would argue that that's
what you say is that notice, he says, yes, that's right. It's notice that it can be negotiated.
In the first instance, we would argue that that's the specific statutory directive that exempts it for collective bargaining. But if you don't find that, if you reach the past practice argument, which I hope that this was correctly, I attribute what Mr. Fly was saying, that you can only have a past practice if you have a term and condition of employment. One cannot accrue into the other. You have to, so it's only if it is a term and condition of employment. But once that is there, you have to do the analysis, Perbs, like first, is it mandatory? Then is it unequivocal? Did it occur for a period of time? And was it for under reasonable expectation? And we present that based on the DOT case, that Perb is very clear that when there's a statement of retained discretion, there cannot be a reasonable expectation of an employee that the benefit will not change. Well, therefore, the employer is privileged to act based on that discretion. And that is from, it's been our position, but it is very clearly Perb's decision, both at the board level and at the appellate division for the DOT case.
Thank you, Counsel.
Thank you.